I am Roger Oatley. I'm here with my co-author, Troy Lehman. Say hello, Troy.
Hello.
You'll be hearing from Troy in a few minutes. This is the first ever audio chapter of Addressing the Jury. It is a chapter in which you will hear an opening and closing address in an actual case, and we will explain how decision-making biases, themes, and other strategies impact on effective closings and openings. I will begin by highlighting just a few of the decision-making biases that are so important to understand when you open your case to a jury and when you close your case. Then Troy will deliver a slightly abbreviated version of an actual opening statement in a recent trial. And during his opening, he will pause from time to time so that I can alert you to what strategies and biases to listen for in the next section. Following the opening statement, Troy will then deliver an abbreviated version of the closing statement in the same case. Again, Troy will pause from time to time so that I can alert you to the strategies and biases and other devices to listen for in the next section of the closing. Okay, let's get started. First of all, what are decision-making biases? I should warn you that I'm only going to touch on a few of them. To understand fully how biases impact the work we do as advocates, turn to the full chapter in Addressing the Jury, where they are fully explained. The first thing to understand is that biases are not prejudices based on ethnicity, religion, or sexual orientation. The next thing you must appreciate is that contrary to what we are all taught in law school, that decision-making is based on the logical application of law to the facts, decisions are more frequently made based on decision-making biases. Sociologists have studied and written about biases for a long time. They call them heuristics. Sociologists believe that the origin of heuristics is in primitive tribal behavior that was based on safety and survival. That's how long biases have been affecting human behavior and decision-making. The first two biases that I will mention are the primacy bias and the recency bias. I mention them now because they are so important in opening and closing statements. Primacy bias holds that we are all far more likely to believe what we hear first. For that reason, it is a great advantage for the plaintiff to go first when making the plaintiff's opening statement. The recency bias holds that we are more likely to remember what we hear last. And again, for that reason, the plaintiff has an advantage in closing last to the jury at the end of a trial. The next bias I will mention is the identification bias. You will hear it mentioned a lot in both Troy's opening and Troy's closing. Identification can be achieved in many ways, all of which are described fully in our book. You'll hear Troy make use of this decision-making bias throughout his opening and his closing, and he uses them effectively. Identification turns on people liking other people. We want jurors to like our client. We want jurors to like us as counsel. It is perhaps the most critical and persuasive bias of them all, especially in opening and especially in closing, but also throughout the trial. The other bias you will hear so much about in this particular case is defensive attribution. It is based on the desire we all have to feel safe. And because of our desire to feel safe, we tend to believe bad things only happen to bad people, or people who deserve the bad thing to happen to them. It explains why contributory negligence findings that seem to defy the evidence so often are made by jurors. You'll see that bias at work in the opening and the closing that follows my introduction. The other bias I'll mention, and the final one in this introduction, is the authority bias. And that holds that people are more likely to believe those who are perceived to be in authority. And it's for that reason that it's frequently a mistake to simply admit that an expert is an expert. It's for that reason that it is always a good strategy for us as counsel to prove the credentials of our expert and to emphasize how authoritative our expert is. In cross-examination on an opposing expert's authority, it is always so important to attempt to minimize his expertise in relation to the expertise of our clients. And you will see later how effectively Troy uses this bias in his closing. As I said earlier, these are just a few of the biases that you'll read about in the chapter on biases in the text, but they are sufficient to help us explain the use of biases in opening and closing statements. The case you are going to hear about is Little versus Sinton Bus Lines. It's a case that I started, even though I retired from active practice 8 years ago, and a case that Troy took to trial just a short time ago. I worked with Troy on the opening and the closing, so I know the case well. At the end of the opening and the closing, we will tell you about the result and the jury's verdict. The plaintiff in this case was a young girl who jumped out of the back of a school bus on her last day of grade 8. For several years before Sarah Little was injured, grade 8 students on her school bus had jumped out of the back of the bus on the last day of school. It was a tradition on this bus. The bus company never did report this tradition to the school. We knew that liability would be hotly contested. Sarah had been a bus patroller in grade 6 and knew it was wrong to jump out of the back of the bus. Moreover, she mistimed her jump and jumped when the bus was still moving. The defendant believed that a jury might dismiss the claim, and if not, that contributory negligence would be very high. So the defendant's pretrial offer, notwithstanding the serious damages, was $500,000 plus costs. Sarah suffered a traumatic brain injury in the incident. We take the position that she was unemployable and incapable of living independently. The defendant would argue that Sarah was compromised by pre-morbid sexual assault. The defendant would argue that Sarah's employability was not significantly compromised and that she did not require much more care than she would have required but for the injury. On liability, our theme was simple, and it was this: adults entrusted with the care of kids have to follow rules designed to keep kids safe. And if they choose not to follow those rules, the safety of the children in their care is compromised. Notice that right at the start of the opening, we focus on the liability theme. The theme of adults who have been entrusted with kids' safety, failing to follow rules designed to protect kids. Presenting the theme at the very outset takes advantage of the primacy bias. We were concerned about the defensive attribution bias. Jurors thinking to themselves, my kids are safe because my kids would never do something this reckless. Notice, as Troy begins, how he jumps right into liability and the theme without wasting time talking about the importance of the jury system and the jurors' roles. As you listen to Troy begin his opening, listen for how Troy introduces the liability theme and how he begins to deal with the defensive attribution bias by emphasizing how the school fails to follow the rules and by emphasizing the tradition that led Sarah to jump from the bus, a tradition that was never sanctioned by the school because the bus line never informed the school authorities so that the school could do so. And with that, if I were the judge, I would say to Mr. Lehman, Mr. Lehman, please present your opening statement to the jury on behalf of the plaintiff. Mr. Lehman?
We're here because of a tradition at the Guthrie Elementary School. It was a dangerous tradition. Year after year, grade 8 kids open the unlocked door at the back of their school bus and jump out as they arrive home on the last day of school. Year after year, nothing is done to stop this dangerous tradition because the bus driver employed by the defendant bus company chooses not to inform the authorities at the school. Before 2011, no child had ever gotten into trouble for jumping out of the back of a bus. There's no punishment. There are no consequences. There are no warnings. As a result, 13-year-old Sarah Little decides to do something she had seen other kids do over a number of years. She jumps out of the back of the bus on her last day of school on June 29, 2011. Tragically, she fractures her skull and suffers a traumatic brain injury that has permanently changed her life. The adults employed by the defendant bus company knew about this tradition. The bus driver knew. The owner of the company knew. These adults knew that the tradition was dangerous because the back door of a school bus is more than 3 feet from the ground, and there's often traffic behind these buses. These adults knew that the children could get seriously hurt jumping out the back of the school bus, whether it was stopped or coming to a stop. Floyd Sinton Limited is the bus company that was entrusted to get Guthrie School children home safely. This company had rules. They're set out in the company handbook. Here are the key ones on the screen. The handbook says that Sinton's employees are required to notify the school if they observe any situation where a child's safety is in jeopardy. The handbook also says that drivers should notify the school principal of any inappropriate behavior by a student on the bus. We'll learn that these rules exist to ensure that the bus company makes the school principal aware of dangerous situations, so that the principal can take steps to discipline kids and eliminate the danger by putting a stop to the activity. These rules exist to keep kids safe. We'll hear that the adults employed by the defendants chose not to follow their own rules. We'll meet a bus driver by the name of Marilyn Shepard. We'll learn that several students jumped out of the back of Miss Shepard's bus in the years between 2007 and 2010. Did Ms. Shepard ever report this dangerous activity to the principal? No, she didn't. Ms. Shepard claims she told other bus drivers about students jumping from her bus on the last day of school before 2011. Did those other drivers report this dangerous behavior to the principal? No, they didn't. Ms. Shepard also claims that she told the owner of the company, Stan Sitton, about this dangerous behavior before 2011. Did Stan Sitton report this dangerous behavior to the principal? No, he didn't.
By this point, Troy has set up the case as being about adults not following the rules that were designed to protect kids, and that they allow dangerous behavior to go unchecked. In the next section, Troy turns to causation. What would have happened if the rules had been followed? The key evidence on causation we knew would come from the school principal. So Troy highlights this crucial evidence that the jurors will hear in the first few minutes of the opening. Notice the use of his questions to keep the jurors' attention and to support the liability theme. Notice that the questions at this stage in the opening are not rhetorical, that is, questions that call for a certain answer, which would offend the rule against being argumentative in the opening. They are just questions.
How do we know that no one from Sinton followed their rules and made a report to the school principal? Marilyn Shepard will tell us that she did not report the dangerous tradition to the school. We won't hear from any driver who reported the dangerous tradition to the school, because no one did. Stan Sinton has passed away, but there's no evidence that he reported the dangerous tradition to the school. We will also get to meet Melody Northrup, who was the principal of the school from 2005 to 2011. She'll tell us that no one ever told her about children jumping out of the back of Sinton buses. She'll tell us that she's disappointed in Sinton because she expected that they would follow the rules and report dangerous activity like this. She'll tell us that she's also disappointed because this kind of incident involves the safety of kids in her care. What would have happened if Sinton's employees had made a report to Melanie Northrup about children jumping out of the back of the bus at any time over those years before Sarah was injured? Melody Northrup will tell us that she would have ensured that the activity never happened again. She'll tell us she would have held an assembly before the last day of school to warn children. She'll tell us she would have told children that jumping out of the back of the bus would be punished by suspension from the bus and potential suspension in grade 9. She'll tell us she would have sent a note home to parents warning them. And she'll tell us she would have sat all of the grade 8 children at the front of the bus during the last week of school.
With the liability themes clearly set out and re-emphasized using different words, Troy now tells the story of what happened. Effective storytelling is an essential strategy. Notice the use of the present tense to involve the jurors in the story as it unfolds. Notice how Troy links Sarah's decision to jump out of the back of the bus to the defendant's failures as a strategy for blunting the attribution bias. You'll have to refer to the book to see the medical illustration of Sarah's skull fracture that Troy will refer to. Why does Troy show this to the jury in the liability section of the opening? It's a deliberate strategy to have the serious injuries Sarah suffered help drive liability.
We'll learn that Sarah Little never gets any of these warnings because no one from Sinton reported kids jumping out of the back of the bus to the principal. No one reported in 2007 or in 2008 or in 2009 or in 2010. Sarah and her twin sister Emma know about the tradition because they see other kids jumping out of the bus on the last day of school over those years. They ride in Ms. Shepard's bus in grade 4, 5, and 6 and see many grade 8 kids make the jump from the back of the bus on the last day of school. As their grade 8 year ends in June 2011, Sarah, Emma, and a friend by the name of Shannon Dooley talk about this jailbreak tradition. They decide to jump out of the back of the bus on the last day of school. They want to be part of the tradition. As the bus approaches her stop, Sarah gets out of her seat. She unlatches the back door and jumps out. Her plan is to jump out just as the bus stops and run home, as she had seen so many other kids do in years before. But Sarah mistimes the jump. She jumps before the bus has stopped. The driver estimates the speed at 25 kilometers an hour. The bus stops just 2 seconds after Sarah jumps. On the driver's evidence, Sarah mistimes the jump by just 2 seconds. When Sarah's feet hit the ground, her body is thrown and she strikes the left side of her head on the pavement. The force of the impact fractures her skull. Here's a picture of the fracture to Sarah's skull. Sarah fractures the occipital bone and the temporal bone, which are located here and here. The doctors that we'll meet will tell us that this is the thickest part of the skull, and it's the hardest to fracture. The blow causes Sarah to suffer a brain injury with very serious impairments that I'll talk to you about in a few minutes.
This last sentence is no accident. It's meant to create some suspense and thereby to heighten the juror's interest when Troy gets to damages. It's a way of using the primacy bias by alerting the jurors that a new section of the opening is about to begin. But before we get there, we want to directly address the most important issue in the case, which is the apportionment of liability. We felt it was important that Sarah take responsibility for actions. This is the right thing to do in cases where contributory negligence is obvious. It advances your credibility as counsel and your client's credibility by acknowledging some fault. We also look to damage the defendant's credibility based on the contrasting aggressive liability position we expect the defense will take, namely that there's no liability at all on the defendant. We also, in this next section, expand on the theme of adults failing children when dealing with the issue of allocation of blame. Notice how Troy uses the questions to the jury that they will have to answer in their verdict to focus the jury on this issue in the way that will be illuminating for the jurors and will thereby enhance his credibility.
Before I get to Sarah's injuries, I'd like to talk to you about your role in determining fault. At the end of the trial, you're going to be asked to answer a number of questions. You'll be asked whether Sarah Little was at fault or negligent. You'll be asked whether Floyd Sinton Limited or its employees were at fault or negligent. If you find both Sarah and the bus company to be at fault, you'll be asked to allocate their degree of fault in percentages on the basis of whose conduct you find to be most blameworthy. Even though Sarah was only a child when she was injured, she's prepared to take responsibility for her actions. She'd been a bus patroller in grade 6. She knew that jumping out of the back of a bus was against the rules, whether the bus is stopped or moving. We admit that Sarah is partially at fault for making the decision to jump out of the back of the bus. While Sarah has accepted that she is partially at fault, the adults at the bus company, in their statement of defense to this lawsuit, deny the plaintiff's damages, if any were caused or contributed by any negligence or want of care on their part. That's what they say in this document. Mr. Percival may say that Sarah, the young girl, is solely responsible for her injuries, and that the adults at the bus company, who did nothing about the tradition for 5 years, are not to blame at all. Mr. Percival is entitled to take that position, but you'll have to decide whether that's a reasonable position having regard to the evidence. At the end of the trial, it'll be up to you to determine fault, and if you decide both parties bear responsibility, to decide who is most at fault as between a 13-year-old girl who made a poor decision to follow a tradition and the adults at the bus company who knew about the tradition for years and who chose not to follow their own rules and report it to the principals so that it could be stopped. At the end of the trial, I will be asking you to find that most of the fault rests with the adults at the bus company, but that's a decision that you will make based on the evidence that you hear.
Troy is about to turn to damages. And I should mention that you will see Troy use the strategy of inoculation. Inoculation is fully described in the text, and you will want to read it because it is such an important strategy. It is a device where you acknowledge the apparent strength of a defense argument and then explain why the argument is not sound. It is a way of taking the sting out of an argument and a way of enhancing your credibility for acknowledging it. So as Troy turns to damages, notice how the first thing he tackles is the defense argument that Sarah was already compromised by her traumatic past. Listen for how he does that through the strategy of inoculation. He does this by acknowledging the issue and then highlighting Sarah's high level of function before she was injured in the incident. Notice also the powerful photograph of Sarah and her family, which you will find in the text. It's a family photograph that is so effective that it not only drives damages, but liability as well. Pay attention also to the family story that paints Sarah's family as an underdog that has coped with adversity and succeeded. We all love to help underdogs because we identify with them. There's a bit of an underdog in all of us. As explained in detail in the book, identification is another powerful strategy in any case where it's available.
Let me turn now to tell you about Sarah Little. As I've told you, Sarah's a twin. She has an identical twin sister, Emma, who we'll get to meet. Here's a picture of Sarah, Emma, and their mom, taken just days before Sarah was injured. Sarah and Emma were adopted at birth by Christina and Ian Little. Christina had always wanted children. Well, we'll hear how she spent $100,000, money she inherited from her father who was killed in a car crash, to try to have children of her own. But the fertility treatments didn't work. Then Christina met the twins' teenage mother, who had decided to give them up for adoption. She adopted them, and Christina is the twins' mom. Sarah enjoyed a normal infancy, as did her sister Emma. They met all their developmental milestones. Christina's marriage with Ian Little ended when the twins were only 2 years old. Ian moved out to British Columbia, and while he maintained contact with the twins, for all intents and purposes, Christina became a single mom. Christina did her best as a single mom to provide a stable and loving home to her daughters. She provided for them by working in a group home and then operating a bridal store. Tragically, both Sarah and Emma were sexually assaulted when they were young. Sarah was fondled by a boyfriend of Christina's when she was only 5. Emma was subjected to a longer period of abuse by this boyfriend and by a babysitter. The girls didn't report the abuse to anyone right away, but ultimately they told their mom about it. The police were involved and there was a criminal trial. These were awful events that impacted the whole family. Emma struggled with sadness and shyness. She required significant counseling. Sarah, too, had issues with sadness, but she remained much more outgoing socially and more positive than her sister. She didn't require the same level of counseling that her sister did. Christina was traumatized as well and became quite protective of her twins. In the years before she was injured, Sarah was healing from the trauma of the sexual abuse. The people who knew her will describe her as a positive, easygoing, and kind kid with a wide circle of friends before she was injured. In fact, we'll learn that at times Sarah was too outgoing and social. In grade 8, she received a couple of pink slips on the bus for excessive noise, carrying on like 13-year-old girls sometimes do with friends. Academically, Sarah didn't always apply herself to her fullest extent. Her marks were in the B and C range. Her average in grade 8 was 67%. But the comments on her report card indicate that she had the potential to get better grades, and no one was concerned about her ability to graduate high school and live a full and independent life.
In the next section, Troy will turn to Sarah's injuries and her impairments and the impact of them on her function. As you hear this part of the opening, listen for the following. First, the use of simple but dynamic language to describe what happened to Sarah's brain when she hits the ground. Next, the use of continued use of the present tense to keep the jurors' attention and involve them in the story. 3, telling the story of the impact of Sarah's impairments on the entire family. Next, how Troy inoculates against the defense argument that Sarah would have been compromised by the premorbid sexual assault by using the twin sister Emma as a comparator. Ideally, we want to set this up so that the more the defense takes the position that Sarah's sexual abuse doomed her to failure, the more it hurts the defense case. And finally, notice how Troy highlights key examples of what the jurors will hear about her need for attendant care, about how her impairments create a propensity to spend money, and a propensity and risk for her being taken advantage of sexually.
Now let me tell you about Sarah's injuries. Emma and Shannon Dooley jump out of the back of the bus after Sarah. They find her lying unconscious on the road. Emma thinks her sister is dead. By the time the paramedics arrive, Sarah is still lying on the road. She regains some consciousness, but she can't respond to their questions. The paramedics rush Sarah by ambulance to Soldiers Hospital in Orillia. She can't answer simple questions. She has no recollection of jumping out of the bus or the past 2 days. Her first memory is waking up at the hospital and vomiting all over herself. A CT scan shows the fractures that we looked at a few minutes ago to the thickest part of the skull. We'll hear from the medical experts that the force of the impact jars Sarah's brain within the skull, causing it to slosh from one side to the other, resulting in traumatic brain injury. Because of the severity of her injury, doctors transfer her to the hospital for sick children. Sarah's kept at Sick Kids for a week. She's drowsy for much of this admission. She struggles to walk. The left side of her body doesn't work properly. She has trouble hearing from her left ear. Her personality is different. She's angry and frustrated rather than easygoing. Her thinking is cloudy. Sarah doesn't leave hospital after Sick Kids. She goes to Holland Bloorview Kids Rehabilitation Hospital for more than a month. The experts there note her to be unsafe in the community. She doesn't look for cars when walking. She needs reminders to interact with people and to take care of personal hygiene like showering. The doctors at Bloorview recommend that when she goes home, Sarah must receive supervision, occupational therapy, speech therapy, and extensive accommodations in high school because of her impairments. We'll hear from Sarah's family that the brain injury transforms her into a completely different person. Her mood is low and flat for most of the time, but she angers easily and for no reason. She overreacts to simple things. Her thinking is rigid. She gets stuck on thoughts and can't get them out of her head. She's constantly exhausted. Sarah attempts to start high school in the fall of 2011 at St. Joseph's High School in Barrie, and we'll learn it was a complete disaster. She finds school confusing. She doesn't understand the material. She gets increasingly anxious. Trying to pay attention wipes Sarah out and her fatigue worsens. She misses a lot of school and doesn't pass a single class in her first semester. Sadly, Sarah's twin sister Emma bears the brunt of Sarah's anger. We'll learn that Emma has been traumatized by the incident as well. She sees her sister lying on the road and thinks she's dead. She begins to have flashbacks and nightmares, and her mental health deteriorates to the point where she becomes suicidal and spends 6 months as an inpatient before coming back home in March of 2012. We'll learn that Emma's absence causes Sarah to deteriorate emotionally. Additional supports and accommodations are put in place for Sarah in her second semester of grade 9. But even with these supports, she's only able to obtain 3 credits. Dealing with a brain-injured daughter and a second daughter struggling to cope becomes too much for Christina. She suffers a breakdown and has to be hospitalized towards the end of 2012. The twins are sent to Florida to live with their grandmother and their uncle. Sarah's put in school in Florida, but again, she struggles and fails to obtain a single credit. After they returned from Florida in June 2013, the twins are enrolled in the Barrie Alternative School, but at different campuses because Emma wants separation from Sarah. The Barrie Alternative School has small classes. The students have more one-to-one time with teachers. Sarah receives a number of accommodations that Emma doesn't need. We'll learn that over the past 4 years, Sarah's twin sister, Emma, has gone on and lived the life of a highly functioning young woman. But Sarah, with her brain injury, has languished and fallen further and further and further behind her sister. She continues to function much like an immature 13-year-old girl. Emma graduates from high school as an Ontario Scholar. She wins a number of awards, including the Governor General's Award for the highest marks at her school. Sarah, on the other hand, only graduates from high school because of extensive accommodations. Emma is accepted into a liberal arts university transfer program at Seneca College. This program will allow her to get her bachelor's degree from York University. She wants to be a teacher. For Sarah, the experts we'll hear from will tell us plainly that because of her brain injury, she has no prospect of succeeding at post-secondary education, and she'll never work competitively. Emma is living independently in a school residence with a roommate. Next year, she'll rent an apartment. But Sarah continues to require adult supervision, lives at home, and is cared for by her mom and a number of caregivers. We'll learn that Sarah has ongoing impairments in a number of different areas. The first area, the doctors call cognitive impairment. Her short-term memory is poor. She struggles to focus and concentrate. Her thinking is rigid. She continues to get stuck on a topic and she can't get it out of her head. She's slow to process information. But perhaps worse than these cognitive impairments are what the doctors call behavioral and executive function issues, which are common with traumatic brain injury. Sarah lacks motivation. She must be prodded to engage in productive activities. We'll hear that she goes days and days without showering. She remains quick to anger for no good reason. She lacks a social filter and says inappropriate things. Her judgment is impaired. She's impulsive. Without supervision, she'll spend money on frivolous things. We'll hear that she recently spent thousands of dollars of her sister's money on the internet. We'll learn that Sarah's ability to function socially is impaired. She's lost her friends. She turns people off by saying inappropriate things. She's vulnerable around men. She struggles to say no to sexual advances, even though she wants to say no. We'll hear that this has led to a very upsetting, unwanted sexual encounter. Sarah also struggles from a number of physical problems. She has headaches and back pain. She has visual disturbances. She has ringing in her left ear. She requires a lot of sleep because she struggles with fatigue. Finally, Sarah continues to struggle with emotional impairment. Her mood is up and down. When it's down, it's a major concern for her loved ones because she's tried to kill herself. Because of these issues, Sarah has been found by a certified capacity assessor to be incapable of managing her property and her personal care. Her mom has been appointed as her power of attorney.
Troy is about to turn to the expert evidence in the case. This was a case where the defense was so certain of its liability position that it did not obtain any defense medicals other than a future care report. This allows Troy to say that the medical evidence for the plaintiff will be unanimous and to trumpet the qualifications of the experts for the plaintiff, which were impressive. Recall the importance of the authority bias as Troy emphasizes the credentials of the plaintiff's experts. Troy will further inoculate against the defense arguments concerning Sarah's premorbid issues by highlighting the evidence that will come from these doctors about Sarah being particularly vulnerable to trauma because of her childhood abuse.
We've arranged for Sarah to be assessed by two of the province's leading experts in traumatic brain injury. We're going to hear from Dr. Don McGregor, who's a pediatric neurologist with the Hospital for Sick Children and a professor at the University of Toronto. She'll testify that all of Sarah's current impairments result from her traumatic brain injury. She'll tell us that the behavioral and emotional symptoms that Sarah is experiencing are commonly caused by brain injury. And with respect to the future, Dr. McGregor will tell us that Sarah will never live independently and will always require supervisory care. We're also going to hear from Dr. Anthony Feinstein. Dr. Feinstein is a neuropsychiatrist. He's the director of the Sunnybrook Hospital Traumatic Brain Injury Clinic. Dr. Feinstein will tell us that Sarah's ongoing impairments are caused by her traumatic brain injury. He'll explain that as a survivor of sexual assault, she was particularly vulnerable to the consequences of brain injury. Dr. Feinstein will tell us that none of Sarah's behavioral and emotional impairments would have arisen if she'd not been injured on June 29, 2011. In other words, he'll tell us that Sarah would be living a normal life were it not for her injury. Like Dr. McGregor, Dr. Feinstein will tell us that Sarah's future is bleak. Her prognosis is poor. She's incapable of gainful employment. She will never live independently and will continue to require 24-hour attendant care. In addition to these medical specialists, we'll hear from some medical and rehabilitation professionals who have treated Sarah for years and who are familiar with her issues. Sarah has seen dozens and dozens of medical and rehabilitation professionals since she was injured. You'll be relieved to hear that we're not going to call each and every one of these people. We will call a selection of them to get you the information that you need, and you'll have the medical records for the rest. One very important rehabilitation professional that you will hear from is Mary Anderson. She's a rehabilitation nurse with a wealth of experience assisting injured children integrate back to school and work. She worked with Sarah and her teachers for years. We'll hear that Ms. Anderson agrees with Dr. McGregor and Dr. Feinstein that Sarah will never be capable of working or living independently. What you won't hear in this trial is any doctor testify that Sarah will be capable of working or living independently. The defense will not call any doctors to testify.
In this next short section, Troy deals with Sarah's no-fault benefits claim and her entitlement to those benefits. Why did we do this? It's because we anticipated and were concerned that the defense might try to mislead the jurors into expecting that no-fault benefits would pay for all of Sarah's needs. We felt that the jury needed to understand that although such a claim exists and had funded Sarah's care in the past, the impact of the claim would not affect the assessment of the damages in the future.
You will learn that Sarah has received this treatment and care paid by her mother's auto insurance company for no-fault benefits. You'll learn that these benefits have paid for treatment that Sarah's doctors have recommended, but which is not covered by OHIP. These include important forms of treatment like occupational therapy and counseling, and the cost of medications, to name a few. Sarah's mother's insurer has also paid an attendant care benefit that has allowed Sarah to be supervised by a combination of her mother and support workers. It's important for you to know about the existence of these benefits so that you can understand how Sarah has been paying for her treatment and attendant care. However, when it comes time for your verdict, Her Honor will instruct you to calculate Sarah's damages, assuming that no-fault benefits will not exist after the trial.
In the next section, which is close to the end of the opening, Troy turns to the heads of damages. The damages sought in this case were large. So Troy will tell the jury about the size of the claim in order to prepare them emotionally for the evidence that they're going to hear. Notice especially when you listen to this next section, the language of empowerment that Troy uses that will be repeated again in the closing.
At the end of the trial, you'll have a series of questions about the appropriate compensation for Sarah and her mother. You'll have to determine appropriate amounts for 4 areas of loss. First, compensation for Sarah's pain and suffering and loss of enjoyment of life. Second, compensation for Sarah's loss of earnings. Third, the cost of Sarah's future care. And fourth, compensation for Christina's loss of care, guidance, and companionship due to the injury to her daughter. With respect to the loss of earnings, you will decide how much income Sarah has lost and how much she will lose over her lifetime. As a 13-year-old kid, she had no fixed career path. As such, we're not taking the position that Sarah would have worked in any particular field if she wasn't injured. We'll meet a forensic accountant, Gary Principe, and he'll provide you with information on how to calculate Sarah's lost earnings. He's looked at statistics on what average earnings are for female high school graduates and for female college graduates. If you decide that without the injury, Sarah would have earned the average for female high school graduates and is now incapable of working, as all the doctors predict, Mr. Principe will tell you that Sarah has lost about $1.5 million over her lifetime. If you decide that without the injury, Sarah would have earned the average for college graduates and is now incapable of working, Mr. Principe will tell you that Sarah has lost about $1.75 million over her lifetime. You and you alone have the power to decide what amount is fair to compensate Sarah for her lost income. The cost of Sarah's future care will be a major issue in this trial. We have retained Carol Bierbrier, who's an occupational therapist and a certified life care planner, to analyze Sarah's future care needs. Ms. Bierbrier has consulted with Sarah's treating professionals and will describe for you the cost of Sarah's future medication needs and rehabilitation needs like counseling, occupational therapy, and rehabilitation support therapy. The lifetime cost of these care needs totals about $1.4 million. Ms. Bierbrier will also provide you with information about the cost of providing Sarah with attendant care or supervisory care as recommended by Dr. McGregor, Dr. Feinstein, and others. Ms. Bierbrier will tell us that this will cost between $141,000 and $158,000 a year, depending upon whether Sarah lives with a live-in personal support worker or at an appropriate supported living environment. The lifetime cost of this care is in the order of $6 million. You may hear from a defense future care planner, Shauna Brown. You'll learn that while Ms. Bierbrier has based her recommendations on the advice and the opinions of the medical and treating specialists, Ms. Brown has not. You'll be entitled to weigh her evidence and decide if it's any help to you. You alone will decide what's fair and reasonable to allow Sarah to live safely and productively.
Troy is almost at the very end of his opening statement, and relying on the bias of recency, namely that we remember best what we hear last, Troy will end again with language of empowerment.
I've now said all that I can to help you understand what Sarah's case is about. Her Honor will tell you that it's you, and you alone, that make decisions in this case. It's you who will decide who's at fault, and it's you who will decide what compensation should be paid. We'll do our best to get you the information you need to make your decision and to move the case along as quickly as possible. Thank you so much for your attention.
And at that point, if I were the judge, I would call on the defense to make its opening, at the conclusion of which, if I were the judge, I would ask Mr. Lehman to call his first witness. Now you are going to hear Troy deliver the actual closing address in this case. As you know from the opening statement, we knew that liability would be hotly contested. You also know that our liability theme was that the adults entrusted with the safety of kids broke rules meant to keep the kids safe. You also know from the opening that Sarah Little suffered a significant brain injury with very significant permanent impairments. But as expected, the defendants argued in their closing that Sarah's impairments flowed from her pre-existing emotional issues from sexual assault. As you will see and hear as Troy delivers his closing, that argument concerning Sarah's impairments fell flat because the evidence just didn't support it. As Troy begins his closing, notice especially how he takes advantage again of the primacy bias by starting his closing by introducing the first jury question they'll answer in their verdict, and by reminding the jurors about the liability theme of the case. Notice also how Troy describes the bus driver's conduct as her making choices, which is far stronger than describing her conduct without it being deliberate. Mr. Lehman?
The first question that you're going to be asked when you begin your deliberations is whether there was negligence on the part of the defendant bus company or its employees. Her Honor will tell you that if an employee of the bus company is negligent, that means the bus company is negligent. In answering this question, you're going to be focusing on the conduct of Marilyn Shepard. You'll have to think about the rules that applied to her and the choices that she made. Here's the defendant's handbook. We've seen it many times. The rules are simple. They're set out in the defendant's own handbook. Drivers are expected to report any inappropriate behavior to the principal. Drivers are expected to report any dangerous behavior to the principal. That's what the handbook clearly says. Ms. Johnson told us that's what's expected of drivers. The rules require that a bus driver report to the principal if students jump out of the back of the bus, whether it's stopped or moving because it's dangerous. It's dangerous both because you can injure yourself jumping from that height and because other drivers aren't expecting kids to jump out of the back of a bus door and run off. Every single witness called from the defendant bus company admitted that jumping out of the back door of a school bus is dangerous, whether it's stopped or moving. We met 2 bus drivers in this trial. One of them chose to follow the rules. The other disregarded them entirely. We heard Lily Ellerbrook describe jumping out of the back door of a stop bus as being downright dangerous. Downright dangerous. When she saw that happen on her high school bus, she reported it right away. She testified that a prudent bus driver would report any incident of kids jumping from the back of a bus so that the behavior can be stopped.
As Troy explained during the opening statement, we knew we needed to deal with the defensive attribution bias because we knew that bias could drive a significant finding of contributory negligence. To blunt this bias, notice how Troy doesn't just paint the bus driver as being negligent, but as someone who knew the rules and chose not to follow them, even though the bus driver knew the rules were intended to keep kids safe. In order to minimize the impact of defensive attribution, we felt it was key that we inspire the jurors to feel some anger about the bus driver's conduct. That's the primary purpose of this next section.
Ms. Ellerbrook followed the rules, but Marilyn Shepard chose not to follow the rules. She knew that the rules required her to report inappropriate and dangerous behavior to the school. She knew that jumping out of the back of a stop bus was both inappropriate and dangerous. She said it several times in cross-examination. The fact that she knew it was dangerous behavior and still chose not to report it makes her conduct even more blameworthy. By choosing not to report it, she allowed kids to endanger themselves year after year after year. Ms. Shepard's only explanation for not following the rules and reporting the dangerous behavior to the principal is that it happened on the last day of school. That's no excuse. It's also reckless thinking. The rules don't cease to exist on the last day of school. If bus drivers don't enforce the rules on the last day of school, they create a situation of danger. They're letting children endanger themselves. There was nothing stopping a driver from reporting a dangerous incident on the last day of school. Ms. Johnson admitted that the principal could easily have been called or emailed. Marilyn Shepard knew that if a bus driver allows kids to engage in dangerous activity without consequences, that kids will think the activity is allowed. That's a basic rule of parenting. If you let kids get away with something, they're going to continue with the behavior. Ms. Shepard, Ms. Ellerbrook, and Ms. Johnson all agreed that it was important to tell the principal about this dangerous behavior so that the principal could take steps to put an end to it.
As I said, as introduction to this last section, we felt that inspiring the jurors to be angry at Ms. Shepard and her actions was an important ingredient in our attempt to defeat defensive attribution as much as possible. And the fact that she gave several conflicting statements was of help to us. And notice how Troy stresses her making conflicting statements in an effort to inspire ill feeling towards Ms. Shepard. And notice how Troy asks questions which are designed to reinforce the jurors' ill feeling towards her during their deliberations. Anger or rejection is the opposite of identification. Feelings of rejection toward the defendant would enable us to better take advantage of the identification bias in favor of the plaintiff.
Ms. Shepard's version of events changed drastically over time. Initially, she gives a signed statement where she says kids jumped out of the back of her bus almost every year for 25 years. She tells us she wouldn't have signed that statement if it wasn't true. Then in answers to discovery questions, she says it only happened once, in 2010. And then she comes to court and says it happened twice before Sarah Little was injured. You're going to have to ask yourself, why the different stories? Was she trying to hide or minimize her fault or the defendant's negligence? Was there an attempt to cover things up?
In the continuing effort to minimize the finding of contributory negligence and to promote rejection and anger towards Miss Shepherd, notice how Troy in this next section makes 2 points based on the repeated violation of the rules. Notice how first he points out that Ms. Shepherd was a serial rule breaker. And just as importantly, notice how he ties her conduct into the theme that if you don't enforce the rules, then more kids will break them, which is what caused Sarah Little to jump as part of a tradition that Ms. Shepherd condoned. In this way, we hoped to blunt the defense arguments in favor of contributory negligence.
What do we know from the evidence? We know that kids jumped out of Marilyn Shepherd's bus on the last day of school every year from 2007 to 2010. We've heard from Chris Kennedy and Malcolm McPherson, who jumped out of Ms. Shepherd's bus in 2007. Emily McPherson told us she witnessed kids jumping out of Ms. Shepherd's bus in 2008. We heard from Emily McPherson that she and others jumped out in 2009. Spencer Bennett witnessed this from his front window. Riley Bennett told us that kids jumped out of Ms. Shepherd's bus in 2010. Ms. Shepherd agreed on cross-examination that it's likely that children jumped from the back of her bus every year between 2007 and 2010. Year after year, Ms. Shepherd chose not to report activity which she has acknowledged to be dangerous to the school. Year after year, she allowed students to endanger themselves. Every student who came to court who rode on Ms. Shepherd's bus testified that she did nothing to warn students not to jump. By failing to follow the rules and report it, year after year, she allowed this dangerous activity to continue without consequence. Ms. Shepherd allowed a dangerous tradition to develop. Ms. Shepherd claims to have told Stan Sitton about kids jumping out of the back of her bus. If she did, he too failed to report it to the school. You'll have to decide whether Ms. Shepherd actually told Stan Sitton. If she did, it makes the defendant's conduct even worse because the owner of the company knew about this dangerous activity and did nothing about it. The kids who rode on Ms. Shepherd's bus and who saw grade 8s jump out on the last day of school without consequence naturally wanted to be part of the tradition. Emily McPherson told us that she decided to jump because she'd seen people jump and not get in trouble for it. Based on what she'd seen, it was just something people did on the last day of school. Spencer Bennett told us that in the days leading up to his graduation in 2009, his classmates were constantly discussing how excited they were to be part of the tradition. He wasn't worried about consequences because no one had gotten into trouble and there'd never been any warnings. Emma Little has told us that she wanted to be part of the tradition. She and Sarah thought it was a cool thing to do, something to do on the last day because there were no consequences. Sarah told us that she did it because it was tradition. If Marilyn Shepherd had followed the rules, Sarah would never have been injured. The school principal, Melody Northrup, was frustrated when she learned that Ms. Shepherd had failed to report kids jumping out of the back of the bus between 2007 and 2011. You'll remember she described jumping out of the back of a stopped bus as being very dangerous, both because it's a very high jump that can cause injuries and because other drivers aren't expecting it. She told us that if she'd been advised, as she'd ought to have been, she would have taken immediate steps to stop the activity. She would have held an assembly to warn kids not to jump out of the back door and would have made it clear that there would be consequences, including a bus suspension in high school. She'd have made an announcement in the grade 8 graduation, and she would have sat the grade 8s at the front of the bus on the last day of school so that it could not happen. All Marilyn Shepard had to do to stop this dangerous tradition is spend a few seconds making a report to the principal. A few seconds. Emma and Sarah both testified that they would never have jumped if Ms. Northrup had given the warnings that she told us she would have given. An assembly was held after Sarah was injured, where students were warned about consequences. Ms. Northrup has told us that no one has jumped since. Marilyn Shepard is negligent, and her negligence led directly to Sarah being so seriously injured.
As we told you in relation to the opening, we knew from the beginning of this case that Sarah was going to be found to be partially at fault. Our focus groups had told us that. Sarah knew it was against the rules to jump out of the back of the bus, but here we hope to inspire the jurors to respect and identify with Sarah, because unlike the defendant, she's taking some responsibility for her actions by conceding a degree of contributory negligence. But notice in this next section how Troy walks a fine line, because it's crucial to minimize Sarah's fault by attributing her behavior to the defendant's conduct. In this section, notice the language that is designed to foster identification and to foster erosion of the credibility of defense counsel and his rejection by the jurors by pointing out some unfair mischaracterization of the facts in the opening that he made. Mischaracterizing evidence is a mistake for many reasons, including the opportunity it provides for counsel to attack it in closing, as Troy does effectively in this next section. Remember, as you listen to this next section, that the recency bias results in jurors remembering best what is said last. So in this next section, which is close to the end of the part of the closing dealing with liability, how Troy takes advantage of the recency bias.
You'll next have to consider the issue of Sarah's negligence. Her Honor is going to tell you that children are not held to the same standard of conduct as adults. Sarah was 13 years old at the time she was injured. Dr. McGregor told us about how a 13-year-old's brain is different from an adult's brain. She told us that the frontal lobes of a 13-year-old aren't fully developed. Remember, the frontal lobes control judgment, the ability to think through consequences. Dr. McGregor told us this is why teenagers are more likely to follow their friends and engage in risky behavior. This is important evidence that you'll need to consider in determining Sarah's negligence. Sarah made the decision to follow a tradition that had been condoned by Ms. Shepard. She knew that jumping out of the bus was against the rules, but she'd witnessed a number of kids doing it from grade 4 to grade 7 without getting into any trouble. She'd never been warned not to do it by Ms. Shepard. Several other students made the same decision to follow what they saw as a tradition that had always gone unpunished. In his opening statement, Mr. Percival told you that Sarah jumped because of a dare. We've heard from 5 people on that bus, and not one of them has testified that Sarah was dared to jump. The argument that Sarah was dared to jump out of the bus is an attempt to deflect attention from the real reason why Sarah jumped, because the defendant failed to follow its own rules and allowed a dangerous tradition to develop. Mr. Percival also said in his opening statement that Sarah intentionally jumped out of the bus while it was still moving. Again, the evidence does not support that suggestion. Emma told us that they knew the bus had to be stopped before they jumped, and that was their plan. Sarah was asked on cross-examination whether she agreed with her sister that the bus had to be stopped before jumping, and she said she did. At no point in her evidence did Sarah say she intended to jump when the bus was moving. Emily Plummer overheard the girls talking about jumping and told us that they planned to jump out at Sarah's stop. Sarah simply mistimed the jump. Emma told us that other kids were cheering Sarah on as the bus approached the stop. She described Sarah as getting out of her seat in what looked to be an adrenaline rush. Kelsey Chambers told us that Sarah got up as the bus was coming to a stop. Like Emma, she described Sarah as looking as though an adrenaline rush had got the better of her. Emily told us that Sarah got up as the bus was coming to a stop, and Emma and Shannon Dooley yelled, "Go." The evidence indicates that Sarah got excited and jumped earlier than the girls had planned. People were cheering her on, others yelled "Go," and she went a little too early because her excitement got the better of her. It was a mistake made in a couple of seconds. Sarah jumped when the bus was very close to stopped. Kelsey Chambers and Emily Plummer have both confirmed this. Lily Ellerbrook testified that she brought the bus to a stop 2 seconds after Sarah jumped. So Sarah mistimed the jump by only 2 seconds. We know that the bus was very close to stop when Sarah jumped out because Ms. Ellerbrook brought the bus to a stop at the driveway of 103, which is only a few yards from where she would normally stop. The bus wasn't traveling at a high speed when Sarah jumped. Kelsey Chambers told us that the speed was 15 kilometers an hour. Lily Ellerbrook gave us a range of 15 to 25 kilometers an hour. Now, to put 15 kilometers an hour into context for you, at that speed it would take you 24 seconds to go 100 meters, which is a jogging pace, not a running pace. And there's also the issue of perspective. We've all noticed that speed in a go-kart where you're very close to the ground seems to be so much faster than the speed of a car where you're higher up. And you'll have to ask yourself, to a kid on the bus, how fast would 15 to 24 kilometers an hour have seemed?
As you know by now, our success in the case rested largely on how the jury apportioned fault. In this section of the closing, notice how Troy repeatedly uses the words adult and kid, because our focus groups had told us that this was a key to minimizing Sarah's contributory negligence. Listen also to Troy contrasting Sarah's actions in a couple of seconds as a kid to the repeated failures of the adults over a period of years. By the way, you can't do jury work effectively without conducting focus groups. But back to the closing. Remember that there has been weeks of evidence between the opening statement and what Troy is now saying to the jury in closing. So, notice how Troy repeats the liability themes that we introduced in the opening statement again. You cannot repeat the themes of your case too often. But to maintain the juror's interest, be creative, as Troy does, and repeat the themes using different words that mean the same thing.
Her Honor will explain to you that if you find both parties to be negligent, you have to apportion blame in percentages. In answering this question, you're going to have to compare the decision made by a 13-year-old kid on a bus ride home on the last day of school and an adult entrusted with kids' safety who repeatedly chose not to follow rules well known to her. Ms. Shepherd chose not to report kids jumping off of the back of her bus when she knew it was dangerous in 2007, 2008, 2009, and 2010. She was an adult and trusted to get kids home safely. But she did nothing about kids jumping out of the back of her bus for years. She asked for the door to be closed and she drove away. She never once reported to the principal. This fell below the expectations of the defendant's director of safety, Christine Johnson, and the principal, Melody Northrup. Ms. Shepherd's negligence is what led Sarah and others to jump out of the back of the bus. You'll have to compare Ms. Shepherd's negligence, which occurred over several years, to Sarah's mistiming the jump, which happened in a matter of seconds. You'll have to consider that Ms. Shepherd is an adult who repeatedly chose not to follow the rules intended to keep kids safe, and that Sarah was a 13-year-old girl who fell into the trap created by the defendant of thinking that jumping out of the back of the bus was not a big deal. I told you in my opening statement that I would be asking you to find that most of the fault rests with the adults at the bus company. Based on the evidence we heard, you should find that Sarah's fault is in the 10 to 20% range, and the defendant's fault is in the 80 to 90% range.
You will be interested to know that in spite of defense counsel urging the jury to find Sarah 100%, or alternatively 90% at fault, the jury returned a verdict of only 25% contributory negligence. So clearly, the liability theme and the way it was constantly reinforced resonated with the jury, and clearly our strategies were effective. In the next section, Troy turns to damages. You'll be interested to know that by the end of weeks of evidence, the damages evidence from the witnesses was remarkably internally consistent, and also consistent with what Troy had promised it would be in his opening. We hoped that this consistency had built up our credibility and therefore promoted the jurors' identification with us. For this reason, notice how the first part of the section of the closing on damages hammers home the consistency of the evidence. I didn't mention the frequency bias, which you can read about in the text, but it holds that the more times we hear the same thing, the more likely we are to believe that it's true. This bias was definitely at play as Troy made this part of the closing. Notice also how Troy maintains the jurors' attention by showing the jury the key demonstrative evidence of Sarah's injuries.
You're going to be asked a series of questions about Sarah's losses. Before I get to those, let me make some general comments about the evidence. In many of these kinds of cases, we've got a battle of doctors, with doctors called by the plaintiff testifying about the plaintiff's impairments being serious, and doctors called by the defendant testifying that they aren't. We don't have that in this case. Here, the doctors who testified all agree that Sarah has profound impairments caused by the incident of June 29, 2011. Dr. Feinstein testified that Sarah's impairments all flow from the injury she suffered. He testified that it's highly unlikely that Sarah will ever work or live independently, and testified that if it weren't for her traumatic injuries, she'd be able to work and live completely independently. Dr. McGregor agreed with Dr. Feinstein that Sarah's injuries will prevent her from working and living independently. Mr. Percival didn't even attempt to test those opinions on cross-examination. He didn't call any doctors to rebut their opinions. The opinions of Dr. Feinstein and Dr. McGregor on the severity of Sarah's impairments and their link to the traumatic injury were unchallenged by any doctor. Here's the picture of Sarah's skull fractures that we've seen several times. The doctors who have testified have all described this as much more than a mild brain injury. They've told us about what happened to Sarah's skull and brain. Her head hits the ground with enough force to fracture the bones in the skull that are the hardest to fracture. Here's an illustration that you've seen several times that shows just how Sarah's brain moved within the skull. The force of the impact causes the brain, which we've learned is the consistency of tofu, to move within the skull. It strikes the skull and moves back and strikes the skull on the other side of Sarah's head. You'll remember this image of the SPECT scan. This is ongoing evidence of impaired brain function years later. Dr. Xiao has showed it to us, and he's explained that these injuries are permanent. There won't be any more healing to Sarah's brain. This is also a case where there's a wealth of evidence about Sarah's cognitive, executive, behavioral, physical, and emotional problems. We've heard about Sarah's issues with memory, concentration, and attention from many witnesses. Emma has told us she'll have a conversation with her sister and Sarah will forget about it a few hours later. She's told us that Sarah forgets that she's turned on the stove. Spencer has told us that Sarah will be told to get something upstairs and she'll forget what she's looking for by the time she gets up there. The rehab support workers have told us about Sarah's problem with memory, distractibility, and concentration. We've heard from Emma, Melanie Hay, Liz Yeaman, that Sarah can get so distracted that she's a safety risk while walking. And these deficits have been confirmed by the neuropsychologists. In his most recent report, Dr. Gates described marked impairment of delayed memory and has told us that Sarah's problems with attention and memory are severe enough to significantly impact her at school. Dr. McGregor explained to us that these impairments are caused by a damaged frontal lobe. We've heard lots of evidence about Sarah's executive and behavioral issues. Impairments with respect to initiation, organization, insight, judgment, impulsivity, mental inflexibility, and an inability to speak up for herself. Mariana Phillips, Siobhan Doucette, and Amber Amos have given us so many examples of Sarah's problems with initiation. They've had to prompt and prod her for everything from showering to doing homework. We've heard from Emma and Spencer Bennett that Sarah has no social filter and she says inappropriate things in public. We've heard all about her impulsive spending thousands of dollars of Emma's money. We've heard from the rehabilitation support workers about Sarah's significant problems with planning and organization. Ms. Yeaman has described Sarah's thinking as being very rigid. Sarah's inability to speak up for herself, as we've learned, has resulted in 3 unwanted sexual encounters. Dr. McGregor explained to us that all these issues flow from the injuries to the frontal lobes, and that was unchallenged during cross-examination. With respect to physical issues, we've heard a lot of evidence about Sarah's headaches. She's had these consistently since she was injured. They're serious enough that her treating neurologist, Dr. Slager, has her on gabapentin to treat them. We've heard that without the gabapentin, the headaches are much worse. Fatigue continues to be a major issue for Sarah. All the people who see her regularly have told us that she's constantly tired despite sleeping for long hours. That's been present since the collision, and Dr. McGregor has told us it's a common brain injury symptom. She suffered from back and neck pain since she was injured, which is relieved by massage therapy. There's been a great deal of evidence about Sarah's emotional issues that she's suffered. Her affect is usually flat. We've heard a lot about her depressed mood and her suicide attempt in December of 2015. We've heard about Sarah's issues with emotional regulation from Beth McCaig, her psychologist. How Sarah presents as a person who feels nothing at all or feels severe clinical anxiety or sadness. You'll remember Beth McCaig telling us that she's seen hundreds of teens and Sarah was one of the most impaired with respect to emotional regulation that she's ever seen. The emotion Sarah feels, the one emotion she feels, anxiety, isn't good. It's crippling. It stops her from getting out of bed. It makes her fixate on video games instead of productive activities. It causes her to disassociate, and she feels like she's suffocating. Sarah's family doctor's records, which you'll have with you in the jury room, contain excellent evidence of all of these issues.
Good counsel are sensitive to the needs of their jurors because jurors hate to have their time wasted, especially at the end of the trial when they're tired and want to get back to work and home to their families. Counsel should never attack the integrity of opposing counsel, but if opposing counsel has wasted the juror's time, it's fair game to point it out and to make it thereby more likely the juror will not identify with the defense, or better still, to reject defense counsel. That's what Troy does in this next section. Notice as you listen to the next section how Troy again emphasizes the difference between kids and adults and the level of responsibility we can expect them to take. Now he does that in relation to the mitigation of damages.
At times during this trial, it seemed that much of the focus of the defense case has been to attack Sarah's mom on things she's done and point out that Sarah hasn't received all of the treatment that's been recommended. That evidence, to speak very frankly, has been a waste of our time. This case is about Sarah Little and her losses and needs. It's not about the failings of her mom. It's not about the alleged failings of her case manager, the family doctor, or our OHIP system. Sarah was a kid when she was injured. Shortly after turning 18, she was found to be incapable of managing her property and personal care, with others having to make decisions for her. If they committed sins, those sins can't be held against Sarah. If a capable adult refuses treatment, and there's evidence that the refused treatment would have made a difference to her outcome, her damages could be reduced accordingly. That principle is called mitigation. A capable adult has a duty to mitigate her losses by accepting reasonable treatment that would have made a difference. In this case, because Sarah was a kid, and more recently an incapable adult, that argument is unavailable to the defendant. It's also unavailable to the defendant because there's been no evidence that any of the treatments Sarah didn't get would have made an ounce of difference. In her charge to you, Her Honor is going to tell you that as a matter of law, you can't consider the mitigation argument. Now, you may be asking yourself why so much time was devoted to the issue by the defense if it makes no difference to Sarah's claim. I'm at a loss to explain it.
Now, in the next section, listen for the way in which Troy inoculates against two defense arguments. The first argument is that the jury didn't hear from Sarah's stepfather. And second, how Sarah had premorbid issues that should minimize the damages. Notice especially how Troy does this quickly and then moves on, as good counsel do when inoculating. Spending too much time inoculating lends importance to the arguments and the issues by focusing on them. Jurors will focus on any area that you focus on, so using the proper technique when inoculating is critical to its success.
Mr. Percival has asked you to draw an adverse inference from our not calling Russ Bennett. Her Honor will direct you on whether that's appropriate. All I'll say is that we had lots of evidence about Sarah's life and the trials and tribulations that Christina has gone through before and after Sarah was injured. We could have called Russ Bennett, and we could have gone through the chronology again and heard more evidence about things like who decided to pull Sarah from school and send her to Florida, but I decided it wasn't necessary. And if his evidence was important to the defense theory that Christina's made bad decisions for Sarah, it's of questionable value given that Her Honor is going to tell you that you cannot hold Christina's failings against Sarah. And moreover, the defense could have summoned Russ Bennett as part of their case, but they didn't. Now, the significance of Sarah's premorbid issues have been another issue in this trial. The evidence is that Sarah was fondled when she was about 6 years old. There was a criminal trial when she was in grade 6. Those were obviously traumatic events. They had some impact on Sarah, as they would with anyone. It's clear from Beth McKeag's notes that she harbored some feelings of resentment against her mom for allowing this to happen. That's a natural feeling. But what's important to consider is the evidence on how Sarah was functioning before she was injured. Emma described her sister as being outgoing, creative, fun, and caring, with a good group of friends and lots of energy. Spencer Bennett described her as active, bubbly, and perfectly normal in the year before the incident. Lily Ellerbrook, the bus driver who was Sarah's regular in grade 7, testified that she was social, outgoing, and had lots of friends. Sarah's marks were slightly below the median, but the comments on her report cards indicated that she could do better if she applied herself just a little harder. Sarah's sister Emma was abused on more occasions than Sarah and suffered the effects of the abuse to a much greater degree. She was struggling emotionally before and after Sarah's injury, but has recovered to the point where she's going to a college program and living independently. What's the difference? She doesn't have the permanent brain injury that Sarah has. The sexual abuse history did make Sarah more vulnerable to the effect of the brain injury than someone without that history. Dr. Feinstein has told us it's a red flag for recovery for brain injury and explains why Sarah has done so poorly after her injury. But Dr. Feinstein's opinion is unequivocal that without the brain injury, Sarah would be living a normal life and working and living independently. In other words, he has told us that the history of sexual assault wouldn't have impacted her ability to carry on a normal life if she'd not been injured. Here's the picture from Sarah's graduation that I showed you at the very start of this case. This is Sarah just a few days before the collision, bright-eyed, full of life, and ready to take on high school and life beyond high school.
The next section of the closing is all about reinforcing identification. You will want to refer to the text to see the photograph of Sarah before the collision. Why was it strategic for Troy to show the photograph to the jurors now? Troy does it to take advantage of primacy for the next section of his closing. Closings are always somewhat lengthy. So Troy wants to recover the attention of the jurors and inspire the jurors before the next section to identify with Sarah. In Chapter 6, which is about the power of identification, we talk about the importance of all of our witnesses being likable. In this case, as Troy mentioned earlier to the jury, the defense calls only one expert witness, a future care planner, who was plainly unlikable when she testified. A witness like this can erode all of your efforts to have jurors identify with you and your client, but especially with you as a reasonable, credible counsel. It's an important, perhaps critical strategy to vet all of your witnesses before trial to ensure that every single one of them is likable like you and your client. In this next section on income loss, Troy will focus on how unreasonable it was for defense counsel to call and rely on such a witness. It's another device for helping jurors feel comfortable rejecting the defense position along with defense counsel.
Next, I want to talk about Sarah's loss of income. This involves two issues for you to consider. First, what earnings Sarah would likely have had were it not for the incident. And second, whether Sarah is capable of working competitively with her injuries. Here's something extremely important. Her Honor is going to explain to you a concept called the standard of proof. For findings of fact relating to most issues, the standard is to prove things on a balance of probabilities, more likely than not. But when we're talking about future financial losses, the standard of proof on Sarah is less. Her Honor will confirm that if there's a real and substantial possibility, a possibility, not a probability, that because of the injuries, Sarah will have a financial loss in the future, then you must award those future losses. With respect to what Sarah would have earned if she had not been injured, you might want to consider her twin sister. Emma had the same upbringing as Sarah, suffered a more serious history of sexual abuse, but didn't suffer a brain injury. She's gone on to a college program. Were it not for her injuries, Sarah would likely have achieved the same success. The defense expert, Shauna Brown, gave evidence that Sarah's earnings would have been impacted by her history of sexual abuse. Because she is not a psychiatrist, it would be a mistake to give her evidence any weight on this point. She acknowledged that no doctor supported her opinion. She acknowledged that Sarah was never diagnosed with any psychiatric disorder before she was injured. To the contrary, Dr. Feinstein has told us that Sarah would be working and living independently if she hadn't been injured. With respect to whether Sarah can work with her injuries, we have clear and unequivocal evidence from Dr. Feinstein and Dr. McGregor that Sarah will be incapable of working competitively because of her impairments. That evidence was unchallenged on cross-examination. Mary Anderson, who knows Sarah as well as any of the witnesses outside of her family, testified that Sarah will never work competitively. Not even a part-time job is a realistic expectation. Again, the only witness to opine that Sarah is capable of employment was Shauna Brown. Her opinion was that with some improvement in her condition and supports, Sarah would be employable. She based this on her feeling that Sarah had success in her co-op job working 3 to 4 hours a day. She was completely unaware of the evidence of Amber Amos, who told us that Sarah had so many difficulties with the co-op job and became increasingly tired and depressed as the job went on. Now let me comment on Shauna Brown as a witness. I started my cross-examination of her by putting a very simple statement to her from a judge. The statement was, where a witness offers opinion outside her area of expertise, that suggests the witness may not be fully aware of her duty of impartiality. It's a basic principle that any fair expert would agree to. But not Shauna Brown. She refused to accept the judge's comment, and I suspect the reason she didn't want to agree with the judge's comment is because she knew just how wildly she had strayed from her area of expertise with her own opinion. You'll recall she offered medical opinions clearly outside of her area of expertise about the significance of skull fractures, hypothyroidism, the interpretation of neuropsychological findings, and psychiatric diagnosis, just to name a few. You'll have to decide what to make of her willingness to offer opinions so far outside of her area. You'll have to decide what to make of her tendency to evade questions rather than answer them. You'll have to decide what to do about the fact that she gave evidence about a change in the Ontario Shore's eligibility criteria that clearly wasn't true. It would be a mistake to give any credence to Shauna Brown's opinion that Sarah could work in some capacity based on her ability to do a co-op. Based on the evidence we heard about the co-op, that experience is evidence of Sarah's inability to work competitively, not the other way around.
Now Troy is turning to future care. Because in a case like this, it is such an important area, it requires a great deal of detail. Troy is, in his closing for you, shortening that evidence and that section of the closing drastically for the sake of brevity. You'll find the full text, of course, in the chapter where the little closing is reproduced. Notice especially in the next section how Troy empowers the jurors and motivates them to award the care that Sarah needs. Remember that jurors want and need to feel that their award will make a difference. It's critical to emphasize that. Notice, too, that Troy reminds the juror of the relaxed standard of proof with respect to future economic damages, and how Troy quickly deals with defense arguments concerning future care. He does not want to focus too extensively on the defense arguments and thereby inspire the jurors to focus on the arguments when they are deliberating.
The next question is about the cost of Sarah's future care. Again, it's important for you to know that the standard of proof is relaxed. All we need to prove is that there is a real and substantial possibility that Sarah will require a medication or a treatment or a form of care, and Sarah is entitled to it. You're to be guided by what's reasonable. A level of reasonable care is what's to be achieved by your verdict, not the cheapest possible alternative. Mr. Percival has made an argument that you should be reluctant to award care costs that Sarah might otherwise need because of speculation that her mother may not spend the money on those costs. That's an argument that is inconsistent with the law and would lead to a cruel and unjust result. It's akin to saying don't send relief to the hurricane victims in Puerto Rico because there's a chance the government won't spend the money wisely. That would deprive the innocent victims of money that they need based on speculation about what the government might do. And that's foolish. Mr. Percival is asking you to do the same thing here. He's asking you to punish Sarah for speculative future sins of her mother. His argument is inconsistent with the law because in Ontario, our law has mechanisms to protect someone like Sarah. A power of attorney is accountable to both the court and the public guardian's office if money is not spent in Sarah's interest. If the court determines that a power of attorney hasn't spent money in an incapable person's best interest, the power of attorney can be removed. Moreover, Sarah has the right to change her power of attorney at any time, and we heard in her evidence that Sarah knows that. Mr. Percival wanted to punish Sarah for the alleged sins of her mother in making his mitigation argument. Her Honor is going to tell you that you can give no credence to that argument. And now he's arguing that you shouldn't make appropriate awards to Sarah because of speculative future actions of her mother. But you must make your decisions based on the evidence, and there's no evidence to support this argument. When it comes to deciding about Sarah's future care, you're going to have to decide between the recommendations of Ms. Bierbrier and Ms. Brown. In doing that, you might want to ask yourself some questions. You'll have to ask yourself which one of these experts was more fair. Which one answered questions directly? Which one conceded the obvious and which one didn't? Which one appeared to make things up on the fly? Which one stuck to her role as a future care planner? And which one gave opinions outside of her area of expertise? Let's talk about attendant care. Now, there's no real dispute in this case that Sarah requires a high level of attendant care. Setting aside Ms. Brown's speculation that a stay at Ontario's shores might return Sarah to independence, which is unsupported by any medical evidence, both of these future care planners agree there's a need for Sarah to live in an environment with supervision. The question is, what kind of environment? Shauna Brown interprets Dr. Feinstein's reports as saying that Sarah's injuries are purely psychological and have nothing to do with a brain injury. Of course, that isn't what Dr. Feinstein said in his reports or in his evidence. He's told us that the brain injury is pivotal to Sarah's issues, and she's adjusted poorly to the brain injury and developed psychological issues as a result of it. But based on her misinterpretation of Dr. Feinstein's report, Shauna Brown says that Sarah has to go into a group home, and it can't be one that deals with traumatic brain injury. It has to be one that services mental health patients. She claims that she can't find any suitable fee-for-service facilities of that sort, so she recommends that Sarah be housed in a special needs group home funded by the Ministry of Long-Term Care. You'll remember Carol Bierbrier telling us about these places. They're like nursing homes. They're geared to people with severe mental health diagnosis, populated by people with schizophrenia and psychotic breaks. In many cases, the patients have issues with homelessness, and they don't offer treatment at these places. These people are so very different from Sarah. Dr. Feinstein testified that it would be completely inappropriate to put Sarah in a facility like one of those. These government-funded group homes are the bottom of the barrel in terms of cost, and not where Sarah or her loved ones want her to be. She deserves better than that. Carol Bierbrier presented two reasonable options for Sarah's future. Option one is a live-in personal support worker. This would involve Sarah living in her own environment with a live-in PSW in an additional bedroom. She'd be supervised by the PSW, but she'd have a sense of having her own place and the dignity that she so much wants, that we all want. That's what Sarah wants. We heard her say that she wants to get away from her mom, but feels she would need someone to support her. This is the option that returns her to the most normal life, but with her safety ensured. She can have friends and family over whenever she likes. She chooses who lives with her. She'd get treatment and community integration from her treatment team. Dr. Feinstein supports this as a reasonable option for Sarah. Option two is a suitable supported living environment, not a nursing home type. Ms. Bierbrier recommended NIRO, Cheers, or March of Dimes, but focused on NRIO. Dr. McGregor and Dr. Feinstein supported the recommendation because NRIO is the kind of therapeutic facility that Sarah needs. It has a psychiatrist on staff. It offers programs specific to brain injury, psychiatric and behavioral issues, with access to therapists and psychologists. It's clearly a better fit than the government-funded group homes populated by the severely mentally ill. Now, Shauna Brown dismisses NRIO, you'll remember, without any analysis or research. She dismissed it because there were issues at the independent living assessment at NRIO. But she was oblivious to the evidence of Melanie Hay from NRIO, who told us that the residential living facilities are different from the independent living assessment. She hadn't even made a phone call to NRIO or looked at NRIO's website before offering her opinion. Sarah needs to be in a living arrangement that's dignified and suitable to her needs. The government group homes aren't that place. They're the bottom of the barrel. If Sarah lives in one of those facilities, she might very well get worse, especially given Dr. Feinstein's evidence that being around schizophrenics and psychotics would be counterproductive and inappropriate for her.
As Troy approaches the end of the closing, he turns to Sarah's general damages, the damages for pain and suffering and loss of enjoyment of life. In some cases, we don't tell jurors what we suggest is the appropriate amount to award. But because in this case, the evidence justified an amount near the cap, we do suggest an amount. We know that the court will tell the jurors what the cap is in the judge's charge. So in order to appear reasonable, we suggest a number somewhat below the maximum. Overreaching on damages risks sacrificing the identification that by now you've worked so hard to achieve from the opening statement through all of the witnesses after weeks and weeks of evidence, and now the closing.
The last question I want to talk to you about relates to Sarah's general damages for pain, suffering, and loss of enjoyment to life. In considering what to award, you'll want to consider the evidence of Dr. Feinstein that Sarah is unlikely to ever improve to the point where she'll work or live independently. This means that Sarah is going to have to live with her disabilities for the next 40 or 50 years or longer. Things have been bad enough in the past that Sarah has taken medication, not wanting to wake up. Her dreams have been dashed. She knows that her issues are never going away. All of her friends are starting to work and have careers, and her life is moving nowhere quickly. Her Honor will tell you that the most that can be awarded for these general damages is $372,000 and change. Sarah's injuries are catastrophic. We suggest that her general damages be in the range of $300,000 to $350,000.
In the final section you're about to hear, Troy closes the closing. He ends, as you always should, with empowerment. A statement to emphasize to the jurors that their decision is crucial to Sarah living a dignified life. A statement to the jury to make it clear that Sarah can never come back to them again, that their verdict is her last chance for a dignified life. Taking advantage of recency, notice how Troy leaves the jurors with a wonderful visual of Sarah. The very last thing the jurors will hear as they head to the jury room to deliberate.
I'm now coming to the end of my comments. At the end of the trial, Sarah will be waiting for your verdict. And after you've rendered your verdict, after Charles, Aaron, and I have packed up our bags and stored our equipment away. The trial will be over for us, and we'll go on to other things. But for Sarah, she will live with the results of your verdict every day for the rest of her life. This is her one and only chance. She can never come back to court and ask for more money. You are Sarah's only hope for a dignified future. Only you have the power to right the wrong done to her, to give her what the defendant has taken away. Don't have any doubt about what the exercise of this power will do for Sarah, because you will, by your verdict, give her what she wants back most in her life. And that's a life with dignity. It's hard for me to think of anything more likely to put a smile back on her face than knowing she can finally leave her mom's home and live in a suitable and safe environment, a place of her own. Thank you.
Troy, now that your closing is over, we'll pretend the jury has deliberated. Why don't you let us know how long they deliberated, and tell us whether, in your assessment, the themes of liability and the themes of damages resonated, and what finally the award was for Sarah.
Yeah, well, they had 8 questions to answer, more than in a lot of trials. The deliberation lasted about the length of a movie, because I watched one in the lawyer's lounge. It was only a couple of hours before we came back. And the themes certainly resonated on both liability and damages, I'm pleased to say. As you mentioned earlier, on the liability piece, the defendant's position was very aggressive, that there should be no liability on the defendants, or something like 90% contributory negligence. And the jury came back and found the defendant at fault to a degree of 75%, with Sarah being 25%. And it's one of those rare cases, and they're pretty rare, I think, where the jury awarded us everything we asked for on damages. So the verdict before contributory negligence was over $9 million, and over $7 million with the contributory negligence discount. That doesn't happen very often, but I really do think it came down to themes and identification, and on the damages, probably a lack of identification with the defense position and their one witness.
Now, the case was appealed. It went to the Court of Appeal. Can you tell us whether the Court of Appeal varied the jury's verdict or ordered a new trial?
Well, fortunately, the Court of Appeal upheld the trial result in its entirety. I don't do my own appeals. I focus on trials, but I was there as one of the most interested observers, along with Sarah and her mom. And it didn't take the Court of Appeal very long to come to their conclusion and uphold the trial, which was great for this young lady.
I'm going to ask you a last couple of questions, Troy, because I'll bet anyone who has listened to all of this will be wondering what has happened to Sarah Little. Tell us, how long has it been since she received the results of all of our efforts? And can you tell us whether it has made a difference to her life?
Yeah, so the trial was in 2017. The appeal took about 1.5 years, so she's had the money for about 4 or 5 years, and it's made a huge difference to her life. This is a client who I've stayed in touch with over the years. She used part of the money to buy a home that would accommodate a personal support worker, an attendant in a separate apartment. I've been there. It's beautiful. I don't think I've told you this, Roger, but she had puppies and named one of the puppies Oatley, because she said that's a much better name than Troy or Roger for a dog.
I love it. Well, Troy, it is very good news for me to hear, having started that case so long ago, that it worked out so well. I know you labored long and hard over both the opening and the closing and the trial.
Oh, thanks. These cases are always difficult and challenging, but when you make a difference and you get to stay in touch with a client, it certainly makes you feel good about what you do for a living.
Thank you, Troy, and thank you for listening.